Good morning once again and welcome to Employment Hour in 30. I'm your host, John Scholes, alongside my intrepid co-host, Lior Samfiru from the Samfiru Tumarkin law firm. On the show we basically navigate the minefield that is your workplace and your workplace rights and severance and all that stuff where you spend 8 hours a day, 5 days a week at least. So we're going to discuss all kinds of things on the show today, understanding the duty to accommodate, and we'll crush the myth of 1 week per year severance when you are let go. That's all coming up here in the show, and the Severance Pay Calculator as well. It is a busy show this morning on this Saturday, so we'll get right to it. A little more about the show and what we do here, Lior.
Well, John, thank you very much. I'm an employment lawyer, and I only spend half hour here on Global talking about employment law. The rest of my time is spent in my office working with people, helping them understand and enforce their legal rights. But because I get questions all the time, every single day, I start to understand what the misconceptions are, what people believe to be true when it's not in fact true, what issues and problems people actually face in the workplace. So we took that over here, and I want to take this opportunity to talk to people about their legal rights, about the questions that they have about their jobs, if they're having a problem, maybe their boss is doing something they're not supposed to do, maybe they're facing a problem, their compensation is being changed, maybe you lost your job, you need to know what you're owed. These are all important questions. We spend all this time at work. You just said that right off the top. Well, you need to know what your rights are. So tune in right here, right now, and every week we're going to talk and try to demystify this topic of employment law. And to get us kind of revved up and started, let me tell you about the scenario that came across my desk over the past few days. Now, in the past, when we talked about workplace harassment, John, I talked about the idea that to try to resolve it as an initial step, it's always a good idea to try to resolve it internally, to try to talk with the boss, the human resources person, the owner of the company, tell them what's happening, and hopefully the issue can resolve. But that's not always appropriate, and this situation is a prime example of that. So this lady contacted me. She had worked for a company for many years, always had a good relationship with the owner of the company. Now, unfortunately, the owner of the company had passed away, and his son took over. Now, this was a very small office. There was 3 people working in the office. She was one of them, and she did not have a good relationship with the new owner. He didn't treat her very well. He was using very harsh language. He put her down. Nothing she could do was good enough. Created a very bad and toxic work environment. It got so bad that she had to go on a disability leave to deal with her depression and anxiety and stress. And she called me. And normally where I would say to someone, well, you got to try to take it up the food chain internally. But John, here, there's no one to take it to. There's 3 people in the office. One of them is the boss, the owner that's mistreating her. Who is she going to take it to? Well, because there's no one to take it to, John, she has to now deal with it externally. And what I mean by that is if she can't come back to work, and she shouldn't have to given what she had to endure, we can now treat this as a termination, as a constructive dismissal, and have her leave with severance, with her termination entitlements. The reason that is the case, John, is every employee has a right to work in a supportive and proper work environment. That's a very basic right that we all have. So if your boss is mistreating you, if he creates this poisoned work environment, well, what has he done? He's then breached our employment relationship. So if that's happened, I can treat my employment as being terminated and leave and get severance. So I want our viewers to understand that. You don't have to suffer in a poisoned work environment. You don't have to just take it. Yeah, there's other things you can do. You're better off going to a different place where you'll be treated better, and when you leave, you can get severance. If you're a victim of workplace harassment, give me a call.
And contact is very easy, by the way. It is help@employmenthour.com, and the phone number 1-855-821-5900. You know, we're on the radio several times during the week, have been for over 4 years now. Employmenthour.com, by the way, if you want to find a radio station near you that carries the show. Well, it's kind of the genesis of doing this TV show, and all the phone calls we get every week on the show are very interesting. People out there, you know, they can relate to everybody in the workplace. So we like to play a few of those phone calls on the air and get some feedback from you and see what you think. We'll get to one now.
I've been on disability now for just over 2 years, and I received termination papers. First off, were they legally able to terminate me since I was on disability? The second part to that is I had been employed for 4 years prior to that. So there was 4 years where I was actually working and 2 years where I was on disability. But I would expect that I could go back to work in the coming months or within the year.
So what do you think?
Yeah, well, John, an employee should never and can never be terminated because they are sick. An employee should never, ever have to worry about losing their job because they're sick. If you lose your job because you're on a medical leave of absence, that's a human rights violation. Now, in some situation, if you're going to be off for a very long period of time, then the employer may say, okay, enough is enough. You've been off for several years now, you're not coming back, the relationship is ended. We call this a frustration of contract. But if this gentleman was ready and trying to get back to work, even if he's been off for 2 years, the company is not allowed to let him go. That's a human rights violation. And of course, if they do let him go, they owe him severance. They owe him full severance.
Right.
And the time that he spent on a disability leave, those 2 years, count towards his seniority. So if he's been there for 4 years, depending on the specifics of his job, he could easily be getting 6 months severance or more. So number one, you should not be let go because you're on a medical leave or on a disability leave. And if you are let go, despite the fact that I said you shouldn't, you absolutely get severance. Your employer can't say, I'm going to let you go because you're not here, and you don't get severance. That's a wrongful dismissal, plus a human rights violation.
Does the scenario change if he is not singled out, say he is let go as part of a group or a whole section of the workplace?
If he's not let go because he's on a medical leave of absence, if the reason is legitimate, we are shutting down this department and letting everyone go and you're part of the department, then that's fine. That's not a human rights violation. But, John, he still gets severance.
Right.
The fact that he may be off work doesn't mean that you can let someone go that's on a disability leave without severance. When it comes to severance, you have to treat the employee as if they are actively working, earning income when you calculate their severance. And some people think, well, if I'm going to be off for too long, maybe more than a month or a year, well, then they can end my employment. Nonsense. They can't. I know people, and I've worked with clients over the years that have been away for years. As long as there's a possibility that they may come back to work, they're trying to get better, and their doctor says that there's hope, then the employer generally has to keep the job. They're still employees, and if they're terminated, they get full severance.
You know, that length of time thing brings up another point, I guess, under this topic as well. So if someone's off and they get a letter or a call from their employer saying, oh, by the way, in 6 months from now, you're going to be gone. We won't have a place for you. Can they do that?
Well,
or is that just forecasting?
It is forecasting. If you're on a medical leave and your employer gives you notice, well, that notice doesn't count towards your severance because you're not actively at work. Where an employer can't give advance notice is if you're on a maternity leave. Your employer can't say, if you're on a maternity leave, just so you know, young lady, I'm going to not have a job for you 6 months from now when you're coming back.
Right.
Because you have to assess that at the time she's ready to return. There could be human rights violations. Bottom line is you have to be allowed to stay on a leave, whether it's a medical leave, a maternity leave, and if you're terminated because of that, that's a big no-no.
They can't crystal ball it. Is
No,
basically what you're saying.
They cannot.
Yeah.
The assessment should be done at the time the person is ready to come back to work.
Help at employmenthour.com. You want to go to employmenthourtv.ca as well. We get all kinds of questions and employment scenarios through those two sources as well. The phone call, 1-855-821-5900. I'll give you one right now and let you work through this one. Sergey's worked 18 years in an office that recently introduced very high sales targets. A few months ago, his manager put so much pressure on him to meet the quota that he had to go on short-term disability. Should he just resign from the job and start working for someone else, somewhere else?
Yeah. Well, he may actually have to resign at some point, although that would be a constructive dismissal. But here's what I would do, John. And by the way, this is a common scenario. You know, there's been news stories over the past few weeks of employers putting undue pressure on their employees to meet targets and anything else, the employee's health be damned. Well, here's how that works. If your employer now decides to change the terms of employment, now we're going to double your sales target. That's not something they're allowed to do. That's not. That's a change to the terms. It's like saying we're going to pay you half. Yep. If you now have to, in order to make money, double your sales, that's a change. So you may be able to say, I am not going to accept that, and I'm going to leave and treat my employment as being constructively dismissed. Beyond that, if Sergey is sick now, because of that, he's on a stress leave, so he's not going to be able to meet those targets, his employer has to accommodate. We'll talk later about the duty to accommodate. But what this means in this context is his employer may say, okay, if you can maybe only work part-time, we're not going to ding you. Maybe we'll prorate your targets so that you can still make decent income. You can't be penalized because you are legitimately sick. So I would like to talk to Sergey here. I'd like to understand if this is a case for constructive dismissal, that the employer just decide to change the sales target, because if that's what the company did, that's a constructive dismissal. If they're putting so much pressure on him that now he is sick, that itself could be effectively bullying and harassment. That could be constructive dismissal as well. So there's a lot to talk about, and I hope Sergey gives me a call.
For any other employee not off on a sick leave, just working every day, and they have a similar situation where the quota is doubled, or they've changed their work hours, so on and so forth, or their pay for that matter, what's the fallout if they accept it?
The problem, John, accepting a change, any change, so whether you're accepting extra targets or less pay or anything like that, the problem with accepting it is you give the company the right to do it again. So you may think, okay, I'll accept it this one time. It's not so bad. I'm going to be the good soldier, the good team player. That's wonderful. The problem with accepting a significant change is that when they want to do it again a month later, at that point you're stuck because you agreed to it the month before. So it's not a one-time thing. So that's why you have to be very careful when your employer makes a change to the terms of your employment and you just continue working. Continuing to work is the same as if you were saying, yes, I agree. So if you don't agree to something, say it. And if the company imposes it anyway, you may have to treat that change as a constructive dismissal and leave and get your severance.
Including making the phone call, email as well, help@employmenthour.com. There's another resource for you to ask questions. And chances are when you go to terminationquestions.com, not always, but your question might have been answered over the years that you've had this website up and running. Drop-down menu, you can see the answers right there. If not, Lior will give them to you, or a member of his staff at the firm as well. Here's one from you, terminationquestions.com. Again, after 8 years and 2 months of work in computer software, I was suddenly let go. My yearly salary was $89,000, and I was offered 20 weeks of severance. Should I ask for that all in one lump sum? At 57, I'm not sure whether I'll be able to find another job, so I really, really need the money.
So, John, this is a great example of the questions that I get all the time. And the reason why I wanted to bring this particular question as an example is this is such a situation where someone is asking me the wrong question.
Right.
So this person, after 8 years, was offered 20 weeks pay, and her question to me is, should I ask for it in a lump sum? What I say is, wait a second, we're not even there yet. The real question is 20 weeks enough?
Right.
Whether it's lump sum or continuation or installments, that's question number two. Question number one is it enough? And so a lot of people assume that what they're offered is good enough, and sometimes they may call me with questions about their vacation that's outstanding or their record of employment, not realizing that they're owed tens of thousands of dollars in severance. Well, let's then answer this specific question. So what I did is I took this person's facts and their stats, and I plugged that into the severance calculator. We'll talk about more of that in a second. So after 8 years of employment, age of 57, salary of $89,000, she was offered 20 weeks pay. Well, the severance calculator correctly says that for her, she's owed as much as 14 months pay.
What a difference. That's
a difference of $69,000. So the question is not should it be a lump sum payment. The question is it enough? And it's not. It's potentially $69,000 short. And there's nothing unusual about this, John. I get questions like that every time. In fact, many people contact me, they're owed even more than that. So if you lost your job, please be mindful that it's not necessarily a question of did the company give it to you in a lump sum? Did they properly calculate vacation? The first question you have to ask yourself is the severance even adequate? Because as you know, because we've talked about this hundreds of times, in over 90% of cases, it's not even close to being adequate. I can almost guarantee that if you have your severance letter in front of you, that offer is going to be pennies on the dollar, just like with this particular person where it was $69,000 short.
It's not the question they should be asking, and it's also not the thing you should be signing when you look at an employment agreement. It's not always the money, it's always the back end stuff. How are you going to get taken care of in the end, right?
You want to be careful. If you sign an agreement that limits your severance and then it costs you $69,000 and you are arguing as to whether or not you should get 2 or 3 weeks vacation, you got to be careful when you sign things, period.
1 week per year of severance, that is a complete myth. We'll get into that one after a short break. And with the calculation you just made in your head, we'll show you how you can do it as well. It's called the Severance Pay Calculator. That's all coming up here on Employment Hour in 30.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact. In most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first.
And welcome back to Employment Hour in 30. We mentioned it going into the break, Lior. Very important tool. It's been around for, I would say, over 4 years. And I mean this, literally hundreds of thousands of people have used this and had the eye-opening occasion to go, wow, this is something completely different. SeverancePayCalculator.com is what it is. Give me some details. How does it work?
Well, we wanted to make it easy, so the name kind of says it all, right. Severance Pay Calculator. The Severance Pay Calculator calculates how much severance you're owed if you lost your job. So it's very simple. SeverancePayCalculator.com is the place you go to. And then when you're there, you're asked 3 questions, John. You're asked your age, your position, and the length of your employment. You don't even have to think too hard. You just pick it from a drop-down menu. And then you're done. It's going to tell you exactly how much severance you're owed, whether that's 2 months, 6 months, 24 months, or anything in between. It's such an important tool because, as I said in the previous segment, the vast majority of people, almost everyone, when they lost their job, they're not even offered anything close to what they're owed. We used an example before where someone was offered $69,000 less than what they're owed, and that's nothing unusual about it. So that's why the severance calculator is so important. It allows you to make sure that no one's going to take advantage of you. SeverancePayCalculator.com. It's anonymous. It's free. There's no strings attached. It's there for your information. If you don't use it, you're going to lose out eventually. So call me if you want to talk about your entitlements, or if it's Friday after hours and you're not going to get a hold of me, SeverancePayCalculator.com. And even if, by the way, you're not losing your job, but you're curious, right. Same thing, SeverancePayCalculator.com.
Well, you mentioned Friday at 3 when nobody's in the office. When should somebody use it?
Always, John. They should use it always, and that's the beauty of it. Whether or not you're curious, or sometimes people get that spidey sense. Yeah. I think something's going on. I think they're going to let me go. No one's talking to me right now. Well, hey, be prepared. Find out right now how much you're owed, so that when you're looking at that severance letter, you already know. And of course, if you know someone that lost their job, in this time of year, oftentimes companies do restructuring, people lose their job. Well, then get them to go to SeverancePayCalculator.com, be a good friend, make sure that they're not being taken advantage of.
You may have used it in the last few minutes since we've been talking about it, and if not, some people are going to use it as we speak. And they're thinking, okay, wait a minute here, 4 weeks, 12 months, there's a big difference here. So they're saying, is this thing accurate? Has it got a bug in the system? That's what they're going to think, right?
Not only are they thinking that, they're going to ask me, and people ask me all the time. They email me, they call me, what gives? I thought it was a week per year. This says I should be getting 12 months pay after 5 years of employment. How does that even work? Well, these myths of a week per year, that's only with respect to a person's minimum entitlements. Your full entitlements can be 10 times that, and it's based on your age, your position, and the length of your employment. That's why it's not a week per year, or 2 weeks, or 3 weeks. For most people, it's a lot more. That's why the severance calculator is so important. Always call me if you have any questions, if you're not sure. But what I can tell you is that the severance calculator is accurate.
SeverancePayCalculator.com. Let's take it for a quick spin here. According to your calculations, we got one here. Because I am 46, worked 9.5 years in a technical position at $43,000 per year, I should receive 9 to 12 months of severance. I believe the law states that severance is the number of years you have worked multiplied by 1 week's pay. Why is your calculator different? Where am I getting it wrong?
Well, this is exactly what we've been talking about. Yep. People believe it's a 1 week's pay. And by the way, the Ministry of Labor is going to tell you the same thing because they can only advise you with respect to your entitlements. That's wrong, as I said. You're only your minimum entitlement. So for this particular person, let's run through that calculation. 9.5 years in a technical position at the age of 46. Yes, the severance calculator correctly assessed at 9 to 12 months of severance, not the 9 weeks that this person thought. So the difference is anywhere from $32,000 to $43,000. So if this person didn't use the calculator, if they simply followed their assumption that it's a week pay per year of service, they would have lost out on something north of $32,000. That's a big deal, John, especially if you lost your job. You need every dollar you can get so that you can support your family, pay your bills. SeverancePayCalculator.com.
If this person had signed, got that pay, and then they watch the show and they go, oh man, can I call you now? Can I go back? Can I get more? what happens?
Yeah, if you signed off, and gosh, this happens all the time, and it always upsets me to have to say this and break the news. How do you say to someone, yeah, you would have been owed another $50,000, but too bad, I can't help you. But that's the problem. If you sign off on that severance offer, that's it. You've accepted it. It's a contract. It's a deal. You can't back out of it. That's why you don't sign it. Not until you speak to me. Certainly not until you use the severance calculator. Once you've signed it, I can't help you. You're stuck. And even if it means you're owed another $100,000, and I've spoken with many people where that's happened, you still can't do anything about it.
We do a 1-hour weekly radio show. If you want to find out a station near you that carries it, employmenthour.com. And we take a ton of phone calls on the air as well. By the way, you want to contact Lior or a member of his team anytime, 1-855-821-5900. We'll get to a call here and let you go through it.
I worked for a large HVAC company, 3 years, non-union company. I finished my third term apprentice and moved into my fourth, and I never got a raise. And I've been trying to sit down with my boss and discuss this raise. Whenever I questioned him about it, he says, yeah, we'll talk about that tomorrow. So whenever the next day came around and I went to have this meeting, I was let go with the story of, while we're downsizing, I don't have any work, even though we're booked 3 weeks out with calls. Later that day, I saw my job posted for much less than what I was making. So I think I was let go just because he didn't want to pay me what I was owed.
Not an odd scenario at all.
No. I mean, you and I have both spoken to people like that. I've spoken to hundreds of people like that. So let's break this down a bit. So he spoke with his boss about getting a pay raise because he hadn't gotten one. And before he knows it, his boss lets him go. And of course, looks to hire someone probably to pay them less. So if I were to tell that to any reasonable person, they would say that is wrong. And on many levels, it's completely wrong, from an ethical standpoint, even from a business standpoint. But from a legal standpoint, John, an employer can let you go for such a lousy reason as long as severance is paid. So yes, can your employer decide to let you go and hire someone and pay them less? Unfortunately, yes, but severance has to be paid. Now, this person didn't receive severance probably because of one of the other misconceptions, and that is that people that work in the construction industry don't get severance. Nonsense. You get the same amount of severance even if you're in construction. Of course, we're talking about non-unionized employees, John. You get the same amount of severance. So if you're working in HVAC and your company lets you go for whatever reason, you get severance. And it could be substantial. It could be 6 months, 12 months, 24 months pay. So that's why this person should be giving me a call, and I'll help them get that severance. But it's an important call because you cannot be let go if you're in the construction industry or any industry without severance.
Again, 1-855-821-5900 is the number. Understanding the duty to accommodate. We talked about it a couple times already. We'll delve deeper into that after we take a short break. And anytime, employmenthourtv.ca as well. Employment Hour in 30 continues. Hang on.
Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact: the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact: over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.
Welcome back to Employment Hour in 30. We'll get to understanding the duty to accommodate, what that's all about. If you've never heard of it, we will cover it here in just a few minutes. As I mentioned, though, weekly radio show we've been doing for about 4.5 to almost 5 years. You can go to employmenthour.com to find a station near you where you can catch that 1-hour program on the show. We discuss matters like this. We also take a ton of phone calls, and we'll have to get some of them on the air and see what you think. Let's get to another one right now.
I work for a fairly large organization. I'm a senior management there. I've been there 23 years. I know there's a lot of hours that I put in because of my role, but recently I had one of my key reports resign over the last 3 months. So I'm pulling in anywhere from 70 to 76 hours per week. I've been asking for compensation, and I'm not getting any response, and I'm wondering where I stand, if anything, on that.
That's a lot of work.
That's a lot of hours.
That's a lot of hours.
Oh my gosh. But what strikes me here is that that's a fairly recent thing. That wasn't always the case. So he's now having to work more because someone left and his boss, the owner of the company, didn't replace that person. I guess the owner figured, hey, if I can get this guy to do 2 jobs and just pay him the 1 salary, I've saved a lot of money. Well, wait a second, not so fast. If your employers change your job, so now you have to do 2 people's work, and because of that, instead of 45 hours, you're working 75 hours a week, well, that's a significant change to the terms of employment. That means you potentially can treat that as a termination, as a constructive dismissal. It's a change. It's like any other change. If you go from 45 to 75 hours, or even if it's from 45 to 55, it's still a significant change. So for this particular radio listener that called us on a radio show, what I would say to him is, yeah, do exactly what you're doing. Try to talk to your employer about compensating you so that you feel that it's fair. But if your employer won't, at that point you have to make a choice. And that is, are you going to continue working and not get paid what you should be getting paid and working 75 hours a week? Or are you going to say, no, I'm going to leave with severance? The caveat here, John, and it's important, you're smiling, you're probably going to ask me that, is that you have a very small window to do this. You can't take your time deciding.
A year from now.
You can't. If you take a year, even if you take a few more months, you're going to be considered to have accepted this, and then you're stuck. So I'm going to say to him, take the next couple of weeks, and if your boss won't do anything to help you, it's decision time. Either you're going to stay, and it is what it is, or you're going to leave there and say, enough is enough, I'm going to get my severance and move on. And if that's what you're going to do, give me a call.
1-855-821-5900 is our number anytime, or help@employmenthour.com as well. We talked about it, understanding the duty to accommodate. First of all, for everybody who doesn't know, what is a duty to accommodate?
The duty to accommodate, John, is one of the most fundamental tenets of employment law, probably of our legal system completely. It recognizes that some people have rights because they're more vulnerable, and others that have power have to accommodate, have to help them. So the duty to accommodate says, in the context of employment law, that an employer has to provide some support and help to employees in certain situations. Oftentimes it's in the context of a disability or a medical leave. If I'm not healthy and I need you to help me do something as my employer so I could do my job, maybe you could provide me modified work or give me some flexible hours or allow me to work from home. If doing those things is what the duty to accommodate is to provide that accommodation that I need so I can continue doing my job. They could be also in the context of religion. So if I, for example, observe a religion that requires me to be at a church or at a mosque or a synagogue Friday afternoon, you may have to accommodate me by allowing me to leave my employment early. So there's a number of things that fall under this rubric, and it's a very strict duty that employers have.
Who has the right?
So everyone working in Ontario has the right to the duty to accommodate, as long as the duty is tied to a recognized right. What I mean is it has to be tied to something like race, ethnicity, religion, disability. You can't be accommodated because you prefer 1970s car and then they tend to break down and you're late to work.
Hogan's Heroes at 4 o'clock on a Friday.
No, Hogan's Heroes, no, it's a good show.
It's not going to work.
Despite that, no. But if you have to be at home at 4 because you have to take certain medication or because of another health reason, then your employer has to accommodate you, and it's a very strict duty, John.
When's an employee not entitled to that accommodation?
So generally, an employee is not entitled to accommodation if it's too difficult for the employer. If the employer has tried legitimately implemented or try to implement measures, but it's too difficult. Maybe it's too expensive. Maybe it's going to cost a lot of money. Then at some point, the employer can say, yeah, you know what, this is just too much. I don't have to go that far. But what I want that you to understand and our viewers to understand is it's a strict duty. It's not enough for the employer to say it's difficult. Some difficulty is still acceptable. Some difficulty still has to be overcome. It's only when, to accommodate you, John, I'd have to open a brand new office somewhere or I have to lose clients. Well, at that point, that may be too much. But if it means I have to maybe incur a bit of a loss and a bit of a cost, I still have to accommodate you. In my experience, I've seen a lot of employers refusing to accommodate because it's too difficult, but the law still says they have to. It's a very strict duty, what we call up to the point of undue hardship.
So they have to do it. It's a human right, really. It's a job right.
It's a job right. It's a human right. The Human Rights Code, I'm sure most of our viewers have heard of it. It's a very important statute because it protects certain vulnerable people, people that may have certain rights because they're of their religion. We value those things. We want people to be treated equally, not to be discriminated against because of their religion or ethnic values or disability. And part of that is for an employer to accommodate them if they need it.
You want to get contacted now that the show is done for another week, it's 1-855-821-5900. Email is simple, help@employmenthour.com. You can go to employmenthourtv.ca, and we mentioned it. We're going to keep mentioning it every week. You want to find out, if only for the exercise, what your severance offer should be in the case you're let go or a friend or a relative. Very simple, severancepaycalculator.com. Till next time, Employment Hour TV, right here on Global.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.